Welcome to Speaking in Spoons with your host, Christina Brookman.
Hi, welcome to Speaking in Spoons, a chronically ill podcast. I am your host, Christina Brookman, and today we are bringing back the lovely Adriana Torre from Tower Law Group to discuss the topic disability appeals, the case study. Hey, Adriana, how are you today?
Hi, Christina. I'm doing great. Thanks so much for having me back. I had so much fun the last time, and I'm really excited about this one.
Oh, I'm so excited. I love talking to you. I always learn something, and it's just nice to talk to someone who is also so passionate about the subject and about, helping people and a fellow nerd. That's just cool. Um,
Yes.
uh, so, for those out there listening and watching, I asked Adriana on today because I wanted to discuss some specific cases because I thought that might help our listeners and viewers kind of better understand the appeals process and what is happening with judges as they're reviewing things that might give you guys some tips, some advice, and kind of understanding where we are in the world today in regards to disability law. So, Adriana, what presents have you brought for us?
Loads, and they're all printed off because I am a nerd and I love things that I can highlight and, print off and look and then categorize. So I think
Touch, sniff, smell.
all over the place. Um, I think the first thing that I kind of want to do is kind of let's frame this on where we are in the disability process, right? So many of the listeners know that disability is 4 steps within the agency, right? You first got to apply. You do an initial application and you say, I'm disabled and I can't work. The agency will go ahead and gather all your information. They'll send you to a doctor, and then they'll come up with their own decision. They'll say, yes, you are, or no, you're not disabled, right? That stage, about 60+% of the cases get denied. So you're more than likely going to get denied at that initial application stage. So the second stage is reconsideration. And that is the stage where you're telling the agency, do it again, you did it wrong. About 89 or 88 or 85% of those cases are going to be automatically denied at reconsideration stage, right? There's not much that changes from initial. So that's
And
the first.
those are huge statistics. Are there things that cause like an automatic denial? Or,
Well, what happens is that they say, well, it doesn't change our opinion, right? So they'll get new medications, they'll get new treatment records, and the state agency, which is who's making those decisions, really, they will look at it and say, nah, doesn't change our mind. We're going to rubber stamp what we had said before, right?
okay.
That's just it's most I call it automatic because of that high denial rate, right? If
Right.
there's like an 85% chance you're going to get denied, it's pretty automatic that it's just you're going to get a rubber stamp of whatever they did before. So it's very typical of that process to happen. Those numbers really haven't changed in years.
Yeah, so don't feel bad if you're out there and you've been denied. It does not mean you're not disabled. And isn't there like a higher percentage if you have an education and have worked before?
Of denials,
Yes.
yes. So there's certain ages where the younger you are, the more likely you're going to get denied, right? The more education you have, the more skills that you have, the more likely you're going to get denied. So there is a lot of nuance to all of this, but if you look at those numbers, it's going to show you that if you're filing for reconsideration, you're pretty much guaranteed to get a denial just
Right.
based on the numbers from last year.
Yeah.
But if you get through the reconsideration stage, then you get to a hearing with an administrative law judge. And that is a judge appointed by Social Security that will be there, listen to your case, listen to what you're saying, look at your medical records, and they'll make then a new determination. Now, for 2024, those numbers were about 50%, right? They hovered right around 50% of cases that were approved.
Okay.
But if you got denied, then you have to go to the appeals council. The appeals council is the body of judges kind of above those individual line judges that heard the hearing. They make a decision, and that is another rubber stamp, right? Because 80 something percent of those cases are again denied. So you've gotten through those 4 steps at the agency, you're now going to federal court. And what you do is you have to sue the government and file a complaint and say, hey, this is what Social Security had, this is what they said, and here's why it's wrong.
Okay. And
Now,
this is where you come in.
this is where I come in, this is what I do. And it's
Okay.
interesting because that step shows that right now for 2024, which is the latest numbers that we have, 63% of the cases were remanded, which means at federal court, 63% of the cases, they agreed that Social Security got something wrong.
Okay.
That's a big deal. That shows that there
That's
is a
huge.
disconnect
Yeah.
between what Social Security is doing and what they're supposed to be doing.
I think many out there that are applying would absolutely agree with you. Or waiting
And
in those lines.
and it's one of those where it doesn't matter, how good your case is, right? How much evidence you have in your case. You
Right.
can still get denied and have to get to federal court before you get any clear resolution on your case, right? Anything that a fair determination only gets to that stage. It's bonkers that it has to get to that stage, but
And
that's where
I
we
guess
are.
they're kind of, I was rewatching our first episode, where we had Tim Carter on, who was a disability lawyer for 20 years, and he had said they're kind of banking on that. They're kind of banking on people just dropping out, which in their minds is saying they don't need it. But I mean, some people die, some people just physically can't
Yeah.
handle it.
And the numbers don't lie, right? Numbers are
Yeah.
numbers. And I find trends and things. And it's interesting. So for 2024, I'm pulling up the numbers now. There were 2 million disability applications at the initial level. 2
Wow.
million. Okay. And then it drops off significantly going to reconsideration. That first step, it dropped down to about 500,000. That is not even half. Like that is a very, very big difference. And then it drops again almost in half at the administrative law judge level. These are not numbers that we saw back in 2014. These are not numbers from 10 years ago. But these numbers are showing that a lot of people may be giving up, right?
Yeah.
It takes a year plus to get an initial application determination. And during that time, they do pass away. During that
Yeah.
time, they do have other issues, and they get sometimes lost in the system, and they shouldn't. And there's a lot of things that needs to change.
I
But we
mean,
start with
mine
one
was
thing at a time.
approved in the
Yeah.
first, not after the second part, but with the judge, the first judge, it was approved. But that whole process from start to when that happened was 2 years. So and I was fortunate enough to have an advocate help me. Otherwise, I have no idea.
Yeah.
Yeah.
Yeah. And that's why I always like to say it's a marathon, it's not a sprint,
Yeah.
right? This is one where you have to keep going. And sometimes it is getting to federal court, right? If you don't go to federal court, you let the agency kind of they can say whatever they want. And they
Yeah.
can do whatever they want until somebody else holds them accountable. And in this case, for disability applications, that's the federal court.
So don't give up. If you're listening, if you're watching, do not give up. If you need these resources, they are out there for you. And I would like to refer back to something you said in the previous episode with us that I think is so important, because right now there's a lot of talk about fraud and waste. And I you were saying how there is less than 1% of fraud, I believe,
Yeah.
in disability, like in those on disability. And I mean, that is, there is not rampant fraud out there in this, in people on disability. There's a lot of invisible disabilities. So I
Mm-hmm.
think a lot of people, you don't always know what another person is going through medically. And so disability is really between them, their doctors, and Social Security. Uh,
Yeah.
and
And we,
it was families that were still cashing checks from people that were on Social Security or something.
so that is a different kind of fraud so that is fraud within Social Security. On disability fraud, what they're looking at is, oh, so and so down the street is on disability, but I know that they're fine and
Yeah.
nothing ever happens to them. Social Security will send out an investigator. They have an office of the Inspector General who goes out and surveys this person, right? Like they follow them and tail them and figure out what they're doing throughout the day. Those cases are very extremely low. Like the fraud cases for disability are really low. And the agency releases those numbers like every 6 months, and they're extremely low.
Oh, wow.
The other type of fraud, which is checks going out to people that are deceased or checks going out in cash by somebody else, that is kind of like a separate fraud issue. That's not necessarily the fraud that they're releasing the numbers on, right? The fraud that they're
Gotcha.
releasing the numbers on are people getting disability benefits that are fraudulent, like not their, not their Social Security. Those are kind of different issues.
And
But
they're
on the
checking
whole,
that every 6 months. I mean, that's a lot.
yeah, they
That's good.
release those every 6 months, those statistics, by
Yeah.
saying, this is what we found out. This is what we found out now during this period. And, if it were easy to get on disability, if it was that easy to do fraud, everybody would be on disability. And
Yeah.
those numbers are telling us that people get denied. The agency has a disconnect between how it's implementing its own rules and how it should be. And that's going to show that it's something wrong within the agency.
Yes. Yeah. Absolutely. And it's also not, I think there's a disconnect between disability and what people think disability is.
Yes.
The people are getting like hefty checks and all this free food, and like my SNAP is down to $23 a month. And I live in HUD housing for elderly and disabled. So the square footage of my apartment is 425 square feet, which I mean, sure, a lot of New Yorkers identify with. So I just pretend I'm in Manhattan. You know, drinking my electrolytes. But I'm also very, very grateful because it's a necessary resource. So let's talk cases.
I love
Do you
it.
have
This
one you'd like
is,
to start with?
well, I came prepared with a couple of conditions, some of those softer diagnosis, right? Not the, here's the MRI that shows that your back is broken, right? Those are the
Right.
cases that are um, more easily approved, right? Given age and other factors. But I came with some cases about migraines, Ehlers Danlos, and long COVID. So, dealer's choice, which one might you want to start with?
Oh wow, that's hard. Let's start with Ehlers Danlos.
Okay.
Yeah, I'm excited because I think are these are those invisible illnesses. Some can lead to visibility, like they have in my case, but I it is difficult for uh, people on the outside to kind of know all the complexity, including just from reading paper, like a medical report. So, yes, let's get started.
Okay, so I have two great cases on this. And so it's important to remember where we are, right? They've gotten denied throughout the entire process. Now, where your district court would be, where your federal action would be filed, depends on where you reside at that time. Yes, it is a federal case because you're suing Social Security, but it depends on where you reside at that time. So one of the first cases that I have here is one that was filed in Indiana. And this was in the Northern District of Indiana. So each state has most states have more than one district court. And this is a case back from 2021. And this claimant had Ehlers Danlos, along with a host of other things that kind of go with it, right? Fibromyalgia. Um, she also had obesity. She also had POTS. She also had anxiety and depression. So, I mean, all soft diagnosis, all serious in their own and in combination with each other, right? So she files and alleges because she has a lot of chronic pain, hip instability, she has fatigue and joint issues. And the problem was that a lot of it doesn't come up on objective testing, right?
Right.
You can't check for reflexes and figure out Ehlers Danlos, right? Like, don't find that connection with the normal objective findings. So, what happened? The ALJ issues a decision, and the ALJ says, yes, you have the condition, right? But it's not as bad as you say it is because a lot of your physical examinations are unremarkable, right?
Oh my goodness.
So that's part of the softer diagnosis where it relies heavily on subjective statements. My hip hurts. I have migraines. They last however long, right?
I can only sit for this amount of time.
I have pressure here, and that creates a lot of inflammation throughout the head, and therefore I can't concentrate, right? Those are all the types of things that happen with these softer types of diagnosis that you're not going to find on objective physical exams.
Well, and it's important. This is important information for doctors as well to realize how impactful their doctor's notes are in a positive or negative way. Like if they're not putting in those kind of things about how the condition affects the acts of daily living, the ability to do work, the people can't just guess it. They're not going to, Social Security isn't going to guess it. They're going to look at unremarkable. Like we were talking earlier, where I got denied at first a caretaker a second ago. I had a caretaker for years, was feeling a little bit better, got rid of caretaker services. Then my body said, uh-oh. And I reapplied, happened to be having a good day when they came to evaluate me. But the big thing was they saw in a doctor's note where I was reapplying for a wheelchair. I already had a wheelchair. I needed a different kind of wheelchair. And there's this thing now with electronic doctor's notes where it's like checklists, like how is your gait? How is certain, how are your eyes? And a lot of doctors will copy and paste, or whoever their assistant is that's helping them with that. So the nurse like circled where it said normal gait. I'm going in for a wheelchair, and I have migraines that cause weakness and paralysis down my right side. I had congenital hip dysplasia. Do not have a normal gait. Um, so for doctors and nurse practitioners and all kinds of medical people out there, this is so important. Going back to you.
Well, no, because that's exactly what happened in this case, right?
Yeah.
So the judge was relying on the normal gait, okay, intact muscle strength, and just general notes, right? Just general notes to discount the pain. But that had nothing to do with it. And the problem that the court found was so what the ALJ sort of did in this case is they said, okay, yes, you may have some stuff wrong, but yeah, look, you have a normal gait. And look, you have this. But that doesn't answer the question. That doesn't go to the issues that they're talking about. So
Right.
the court said, no, we're going to remand this case and we're going to tell you why. One of the reasons is because the ALJ ignored positive or abnormal physical signs, right? They had um, hip impingement, they had log
Hmm.
roll tests, they had Fabers, they had Trendelenburg's, even like everything that's related to the chronic hip pain that this person was complaining about. Those were positive, but the ALJ decides those don't seem to matter too much because you have these other normal findings.
Oh my
And
goodness.
so you have an ALJ that was looking at evidence, but saying, well, based on some other evidence, it's not that bad. And one of the big problems was some of the records that they were showing to say that the person had normal gait were actually psych records. Psych records are not going to talk about your physical gait, your strength, your other issues, or anything related to
Yeah.
yes. It's just not. But that's what this judge was looking at. And so the district court remanded. They said, no, judge, you got it wrong, right? You don't seem to understand the condition. You don't seem to understand how this gets diagnosed or how this gets treated, right?
And
So,
also, why is the psychiatrist writing about the physical health when they don't like, sorry, that irks
uh-huh,
me. Improper documentation irks me because it is, and I know people are overwhelmed and they have little time and they don't really have the assistance they need and they're running, but like improper documentation is so detrimental to your patient.
yeah. And that's the problem is that patients have very little control over what's in the medical records, right?
Hmm.
They don't really get to see it or challenge it or say, hey, that's not what I said. This
Yeah.
wasn't correct. And that's what happens here. Just the judge was saying, look, ALJ, you had a very bad understanding of EDS, right? This is just not how this condition is. So we're going to send it back and you're going to do it again, right? And the hope is that they do it right that time.
Right.
And so this is one of the cases specifically about EDS that talks about how hard it is for credibility, for the claimants' credibility, right? That the
Hmm.
ALJs can easily say, well, it's not supported by objective findings. It wouldn't be, right? The objective findings you want to look at wouldn't be there. So this is a good one about when ALJs don't understand what EDS really looks like.
And unfortunately, there are so few specialists that really would know what, like, because there are certain ways that you look at it, like, with the Beighton scale and symptomology, like, they can go through all of this stuff, the texture, the feel of the skin, but you have to be one of those specialists.
Right.
And there's so few throughout the country. It's not just like in your state, like the country. And many people, I have Ehlers-Danlos, and many people with Ehlers-Danlos go through years without being properly diagnosed. So going
Hmm.
back to your statement of like records that patients don't get to look at or challenge, you've got years of incorrect, like misdiagnoses and
Yep.
statements about your patient, a lot of them saying, oh, this is psychological when it's not. Like I know you're talking that patient, they did have POTS,
Mhm. Yes.
because oftentimes patients with POTS are misdiagnosed with anxiety when it's actually the heart rate issue. Like it's actually a heart rate issue. So, and like, thank God for my chart these days. Like, it makes me want to smack it sometimes. But the good thing is, I can see, oh, I didn't say that at all.
Yes.
Or
But
this was
then
a
even
miscommunication, misunderstanding, but you still have to challenge it. And the doctor
correct.
has the right to say, no, I'm not changing my assessment. Um, which
The
is,
other issue
yeah,
is that you're challenging it in the messages, right? So you
yeah,
have my chart. That's the only way for you to say, hey, I looked at these records, but this doesn't say that. And then it just, what, lives there forever? Sometimes they do nothing. And
yeah,
that's not considered an examination. That's still considered your statements. So
exactly.
it's not going to carry the same weight as the medical records themselves, and those are likely not going to be changed later on.
Right.
So it's really important. And this case is one of those where you have to know what's in your file and be prepared for a judge to say, well, your psychologist said that you seem to be walking okay.
Yeah. Well, it makes it even more to the fact that you really need to make sure you have doctors that are listening to you and working
Mhm.
with you because that affects your medical record because I think a lot of people and I was in that at the beginning, like you just assume that there's like medical specialists standing right next to the like giving them their medical assessment and that if they don't know of a certain condition, they then call a special, you know what I mean? This doesn't happen, right?
Right. And here's the thing, even when you have, which leads me to my next case, even when you have doctors on board and everything lines up, they'll still deny you. They'll still deny you. And that's
Yeah.
how we get here. So let's talk about another case. And this one was about migraines. So
Mm,
migraines is a pretty big deal for a lot of people. I mean, people can have migraines for days and they can be down. But
yep.
here's the thing. How do you note that on the record? The only time that you're going to see that at the doctor's office is if you're having a migraine in that moment, right? And you can't have any light, you can't have any noise, but then you're probably not sitting in the doctor's office because you probably couldn't even get there because of the migraine, right? That's real
Yeah.
world. That's just what we understand.
Yeah. And worst case, you're at the ER. Like, um,
Right.
but that's if you know to do that. I didn't know to do that at first. So,
Or if you have coverage, or if it's close to you,
exactly.
or if you have transportation. There can
Yeah.
be a myriad of reasons why somebody won't go. But in this case, this was a person who was having severe migraines and it was treated with Botox injection. Okay. So there was several years of Botox injections. She also had ER visits for severe headaches. And while the Botox injections helped, they didn't they didn't cure anything. She still
Right.
had migraines. So the ALJ says, well, okay, this is a condition. It's bad, but it's not that bad, right?
It's
It
a headache.
doesn't it doesn't prevent all work. The problem is, think about Botox injections, right? To even receive Botox injections for migraines, you have to have about 15 migraines a month to get the Botox injection, right? Doctors are not just giving Botox injections to somebody who walks in and says, "Oh, I had a migraine like 4 months ago, and I've never had one since." No,
Yeah.
these are for people who are having regular
Chronic.
chronic migraines that are keeping them in bed, out of work, unable to do activities. So the fact that this person had Botox injections, ER visits, was doing everything right, but still having these migraines, and the ALJ says no. So the big issue in this case, and this was from 2023, I mean, I didn't go far back to find these cases, right? Like these are not cases from the 80s, these are cases from a couple of years ago. And the interesting part about the definition of disability is that it has to be something that prevents you from doing all work, right? So not only just the physical or mental demands, is that you have to be able to sustain work over a period of time, regular and continuing work. That's what we're
Right.
looking for. But if you're having migraines with this kind of consistency, you're not going to be able to show up to work. And that was the issue, right? At the hearing, the vocational expert had testified about absenteeism from a job. And with a condition that is maybe episodic, you're going to have absenteeism. But
Mhm.
the ALJ didn't factor that into their decision. The ALJ said, well, no, you could still do light work. And because you can lift 20 pounds and stand for a while, you're not disabled. But it didn't account for not being able to even be there at the job.
Yeah.
So this is another example of how hard it is to prove disability. ER visits, injections, doctors, records, supportive, everything, consistency.
And a lot of those invisible illnesses, and like going back to Ehlers Danlos too, or like autoimmune conditions, a lot of these things are episodic. They are
Yes.
chronic, debilitating, and episodic. Um, yeah. And hard, I think really difficult to understand unless you live in it or know, like you see somebody living in it. Because
Yeah.
people, I didn't get understand my dad had migraines. There was a girl in my school with migraines. So I didn't really understand it till I started, and mine are a weird kind of their own kind of migraine, but I have mums for those who haven't new to the podcast. It looks like a stroke, but it's not. And that was misdiagnosed for 10 years. But yeah, the episodic part of it, the waves and the, peaks and valleys.
And so this person got denied because the ALJ didn't really consider that. It had to get to district court, right? For the court to say, no, ALJ, you ignored something really fundamental, right? You can't hold a job if you can't show up for it. It's that
Right.
simple. And that's built into the definition of disability. Why did this have to get to federal court? I don't know, right? And that goes to show, like, for a lot of the listeners, a lot of the people that are out there who have been filing for disability, they're like, I don't know why I got denied. I don't know why either. Like, it
It
just
doesn't make sense,
because
you
it
know?
doesn't make sense. You've
Yeah,
done everything you're
but
supposed to do,
don't give up.
but don't give up because it's just Social Security telling you no. They're the only ones who've made the decision. You
Yeah,
have to get to this step for somebody to say, hey, what do you know? What do you do? And this is, remember, 63% of the cases get remanded from federal court. That's a lot.
yeah. That's and were these two cases remanded?
Yes, both these cases were remanded.
Did they end up eventually getting disability?
So we won't know that unless, we had represented them,
Ah,
right?
okay,
These
gotcha.
weren't cases that we've represented. I
Privacy
track,
laws.
yeah, I track the district court cases and the circuit court cases kind of all over, just to see what trends come up and what things happen. But most of these cases, unless there's a new lawsuit, which would be a completely different case number, you wouldn't necessarily be able to correlate it, right? You wouldn't be able to find out. So I hope that they got awarded
Yeah.
on remand, but I've seen cases that have come back and forth that I have personally handled 4 times. The district court has told the agency 4 different times, no, the decision is wrong. You have to do it again.
Wow.
Four
And a
times
lot
for
of
the
it
same
can be
person.
personal bias too. Like disability lives on conditions are on a spectrum. So just
Exactly.
because you know somebody with MS or Ehlers-Danlos or migraines or you have it yourself doesn't mean you know this particular person's experience with theirs, the
Hmm.
severity of it, and how they experience. Because, like you said, with Ehlers-Danlos, there's a litany of comorbidities and
Yeah.
symptoms, but that doesn't mean every single person gets them. And then there's people that get literally every single thing on it. Um, but even if you got every single thing on it, it could not interrupt your ability to work, or it could be extremely debilitating. And
Yeah.
that's, I think, why these are often so hard to
Yes.
kind of, a friend of mine were talking because she had applied for uh, 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 the word is there. Come on. Caretaker. And she also
Gotcha.
was denied, which was just like, because she goes paralyzed with her migraines, and
Yeah.
has long COVID. And so, like, standing to cook for herself, but the person who was doing the evaluation flat out told her, well, I have a friend with this, and they can work.
Hmm.
And it's like, first of all, professionalism, and you need to, yeah, and second of all, you're not a doctor, so.
There is
But
a lot of personal bias and personal judgment that comes
yeah,
into the disability evaluation at the doctor level, at the social security level, just among your neighbors. And
yeah,
it shouldn't be because nobody really knows what's going on with the records, but everybody just comes in with their own bias still.
yeah,
And it's how do you fight that?
right,
It's you just gotta keep going. It's a marathon, it's not a sprint. And what you're looking for is just one person within Social Security to find you disabled, or one person at the federal court to say, Social Security, you got it wrong, do it again,
it's
right?
kind of like a law case, like the jury. You just need just that
Just one,
one person,
just need one. So,
to get it.
yeah.
Uh,
So let's
you
talk
said
about
you
a
had a
case.
long COVID, or what were you gonna say?
This is the long COVID
This
one.
okay.
Now, this one does not have a happy ending, right? Because
Okay.
this one turned out to be an affirmance. And let's talk about what were the details that they used to affirm the case. So this was actually a hospital employee who contracted COVID back in early 2020. And this case
Oh,
was one of the first ones in federal court to talk about long COVID within the disability context, right?
yeah,
Because it takes years through the disability process at the agency, and then you have to file in federal court, and then it's about a year. So it takes a while for these cases to start coming up. And this was from May 2023. So this was one of the first ones to talk about it. But this person contracted COVID, right, in 2020, and it's long COVID. Those symptoms never went away. We didn't know that at the time, right? We kind of know that now more. But she developed, um, fatigue, cognitive impairments, right? So she had that brain fog. She had migraines, memory loss, and post-COVID neurocognitive disorder, right? She had
hmm,
multiple hospital visits, specialist referrals. Okay, so we're talking neurology, pulmonology, infectious disease, and psychiatry, like poker, like full house of
yep,
everybody that she's supposed to go to. She also had neuropsych testing that confirmed all of this.
yeah,
And despite all of this, the ALJ said, you're still not disabled. Now, the evidence of her disability was from, they did botched memory and attention, right? Neuropsych testing placed her in the second percentile for memory recall and fifth percentile for concentration.
mm.
In order to do a job, you have to concentrate for those 8 hours and get that task done, right? It is not you can just do them whenever you feel well. It's, you got to do them pretty consistently.
Well,
So
and
she had,
particularly with long COVID, even if it was a monotonous kind of thing, you can't be up on your feet like bagging. And long COVID and POTS are like sisters, brothers, they're family
yeah,
in that dysautonomia tree. And I like to say, my autonomic nervous system's on crack. It's just
yeah,
not
you
working.
explained it. you explained it perfectly. And that you see how we know this, and yet it had to get to federal court. And so she also had psychiatric and neuropsychologists both concluded that she was unable to work due to marked deficits in stamina, attention, and emotional regulation.
Mhm.
All key things for employability, right? Marked, which means pretty messed up, right? Like this is not, well, it could go either way. No, marked is pretty bad.
They could, yeah.
There was evidence that she stopped cooking and driving because she couldn't remember, right? She would leave the stove on. She would forget where she was going when she's driving, right? This is basics evidence that was in there. The ALJ, however, relied on selective evidence like isolated improvements in her ability to care for her pets and go shopping with help.
Oh, she
And
pulled out the Friskies. Go you.
so that's sort of the evidence that the ALJ used to deny the claim. Now, unfortunately, the district court affirmed. So they upheld the ALJ's decision. And what they said was, listen, the standard here is substantial evidence, right? It's not a high bar. It's not a high hurdle for the government to show substantial evidence, right? It's not, it's just, is there enough here that somebody would agree with what the judge did? So it's a very low standard. So even with the opinions, the doctor's opinions that she's unable to work, even with documented cognitive defects, even with ongoing care and specialists, the court said, well, the decision's not perfect, but it's good enough. There's still enough here to deny. And so this one shows that, long COVID in SSA world it's very hard because you can have good days. That is
Yep.
by its nature, some of these conditions is you have good days. And on that good day, yes, you can feed a dog and go shopping and, do your hair, do the laundry, do those things. Maybe that's what happens. But then the next day, you're out because you did all those activities. You
You
can't
didn't
do
save your
anything.
spoons.
You did. You can't do the next day. And this case goes to show that it's a very high bar for federal court. Now, this case was out of Iowa, right? So there is, perhaps some regional differences within the federal program. It's 50 states, right?
It was
50
also so
states,
early in the COVID, like the pandemic, of really understanding the
right?
severity. And like POTS has been around for decades, but people didn't really start knowing about it until
Right.
long COVID, because unfortunately, so many people have contracted long COVID. Um, yeah,
And it's
it's just brought
mostly
light to dysautonomia in general.
and it affects mostly women. And I wonder
Yeah,
how that has kind of changed in the medical field. It has recently, but it's still something that struggles is the struggle is real. And
yeah.
that's what this case is talking about. It's really hard establishing disability when the illness isn't really well understood. They didn't
And
know, and this was
research
one of the
is,
first cases.
yeah, like women's disorders or women's things that are thought to be more women's disorders: migraine, fibromyalgia, long COVID, POTS, Ehlers-Danlos, like are less funded,
Yeah.
and less, because of that, less understood, which affects clearly affects the court cases.
But
um
what's interesting is that the judge was like, well, she cares for her pets. She doesn't have a zoo. She's not caring for lions or elephants.
right.
She does not have like horses in the backyard. It was her dog. Like how is that to say, well, you could work 8 hours a day, 5 days a week?
Yeah. And like I
And
could care for a dog if I had a backyard, like let it out. Like I couldn't take a dog for a walk, but like, you know, that's just ridiculous.
it is.
It's
And there's a lot of things about taking care of a dog that some people just think like, oh, you pick it up. Who said I picked it up, the dog, right? Even if it's 10
yeah,
pounds, I
massive
can't bend down.
assumptions.
Massive assumptions and bias on, well, this is what I understand taking care of a pet would be.
You
But
must be
I
giving it baths and oh no, my dog's dirty as shit. Sorry.
like it, or you think a dog, you think, well, one of these big dogs, one of these mastiffs, what if it's a
Yeah,
tiny little teacup?
it's
What if
mostly
it's what?
cat.
But there's so much details that need to be fleshed out when it comes to disability. And that's where I find a lot of claimants run into trouble, right? They just say, well, I don't cook, I don't clean, and they don't really give any details because they think, well, the medical records will speak for themselves.
So you really have to paint the picture for these
100%.
judges. Like, I mean, think Lord of the Rings. Like, describe the blades of grass, right?
See, we are
Dickens.
such nerds, and I love it because, yes, that is exactly what you have
But
to
that's
do.
seriously it because you're communicating to somebody who does not know your disorder, who does not know your experience with your disability. I mean, even with disabilities that are more well known, like MS. Like my aunt has MS, former co-host had MS. There's other people in my life that I've known that have MS, and they all experience it differently. Um, so that's why you really so they paint the picture. How do you best paint the picture? What tools can they utilize?
So the best thing to do is to submit as many statements in support of your limitations as possible. People that
Okay.
know you, people that see you, those that live with you, your neighbors, anybody who knows about your condition that can back up what you're saying, submit that. They have to consider it. The agency will have to review it. And it's not that you're going to just submit a bunch of documents that don't have anything to do with it. No, you need people who know and who see. And if they were called on the stand, they would say,
We can
I've
test it.
seen this person have these problems, right?
Okay.
That's what these statements are. They are basically your testimony under oath in front of a judge that basically says, this is my problem. This is what you're not going to see from the medical records.
And submit it all at the beginning because that means, let's say, your state, like Social Security, gets it wrong and you have to do a federal appeal and go to Adriana or someone like though you can't submit new evidence, right? At the federal level.
Right. Once you get to the federal court, that's it. It's based on what did the judge have? What did the judge
Gotcha.
say? And whether that's right or wrong. The best thing to do is submit as much evidence as early and often as you can. You want to
Okay.
show that this is consistent. As you've noticed from the trend of cases, the issue was, well, they found it not consistent with the medical evidence. They found it not consistent with your daily activities. They found it not consistent with your statements. It
And
is
that's what
all
it's all
about,
about, the daily activities. And they call it like acts of daily living.
yes,
Like, and because they can take those acts of daily living and turn it into a possible job that you could do. Oh, you could do dishes every single night, um, by hand. That means that you know,
that means you can use your hands.
you
And
can
if you
use your
can use
hands.
and if you can use your hands, well, then you could do a job that requires you to use your hands 5 hours out of an 8 hour day. That's how they're
But you need to
making,
quantify and say, these dishes are just for myself. So I am just
yeah,
washing one plate, 5 days a
right.
week. And after doing so, I have to take a pain pill or I have to, yeah, I'm in excruciating. I probably can't do the dish the next day. They pile up and yeah.
Right. or the water hurts my fingers. And then what happens is that
Exactly.
I can't feel my fingers. And so I drop things. And so it takes me about 15 to 20 minutes after using that in order for me to feel my hands again for that to work. Like
And then I
whatever the
can't take a shower,
right,
because of
whatever
it.
the case may be, as long as you're detailing what you are going through,
Yeah.
you're gonna that's what you need to do. That's all they're asking you to do.
This is
But
your
sometimes,
opportunity to tell your story. I think
mhm,
people are scared of doing too much, but like do too much because there isn't too much. Like
yeah,
you're and really think of your worst days too. Like sometimes people don't want to think about that, you
yeah.
know? And so writing, documenting it is hard.
There's a question that I get a lot is, well, what if I need money? What if I start working? Can I work? And my always statement is, go for it. Try. I can guarantee you, based on what I know from your records, it's not going to last, right?
Yeah.
It's going to be too hard. It's going to put you back. You're going to go backwards if you try and work, but
That
try
gives you
it.
more information.
And then we can document it. What were you
Yeah.
doing? And what happened after your first day, after your second day? Try it, see what happens, right? But
I
what ends
mean,
up happening is
yeah,
they can't get the job because one, there's a lot of other issues. They're not going to be able to get hired. Nobody's hiring. There's jobs, out there for them to do. So
it's all evidence. But yeah, like you're saying, I think this kind of goes back to something you had said in the last episode. Like they haven't updated the log of possible jobs in how many years?
that since like the 70s, like that was last updated by some of them in the 70s.
Yeah.
Um, they came out shortly after that. I believe they came out with an emergency message where they said, there are 12 jobs you are not allowed to use anymore, Judge, right? You cannot use this number anymore because they don't exist. Now, there is some updates happening with how vocational experts testify and what they have to show and what jobs they rely on. But the issue is bigger than that
Yeah.
because it comes down to whether or not there is a significant number of jobs you can do in the national economy. Okay. One, national economy, crazy, right? Like, two, there's no definition of significant number. It is not like 100,000 jobs is a significant number. Therefore, anything above that is significant.
They haven't legally defined that?
Nope. There's no definition for what is a significant number of jobs. So you have some judges, some ALJs,
Yeah.
saying that 20,000 jobs in the national economy, mind you, national economy,
Right.
20,000 jobs. Well, that's a significant number of jobs. Therefore, you're not
Sure.
disabled. In what world is like 0.008% of the national economy a significant number? It, I don't understand. It boggles my mind. But that's the problem is
Yeah.
that issue. So it doesn't matter, quite frankly, if they find an outdated job. It doesn't matter because the bigger issue is that the definition of a significant number has never been quantified by the agency.
Yeah. I mean, we've quantified hours, but
Mhm.
not number of jobs available. And have they quantified consistency?
They just say regular and continuing work. They
Yeah.
say that means 8 hours a day, 5 days a week, or an equivalent work schedule. So, as long as you're in that framework, that's what
Yeah.
they're saying regular job is. And that's what they have to find you capable of doing.
And really, like, try to work. During the process of applying to disability, I tried to work. I had to quit, um, because I couldn't physically handle doing the job. I also went to DARS the Department of Aging and Rehabilitative Services in Virginia. Every state has one, rehabilitative services, to help people with disabilities try to find work with accommodations and things like that. I was fired twice. I mean, not fired. They closed my case for being too disabled. And my caseworker was like, vocational counselor was so mad when I got denied disability at first, because she's like, I'm, yeah, I mean, I was like bedridden at the time, because we didn't know what these migraines were. And uh, yeah, and I still go through periods. I'm back now trying,
Yeah.
and it's a journey, but that goes also back to what you said. It's a marathon, not a sprint.
Yeah.
And when you're on disability, you can work. Um, it's they want you to work, and there are process. A lot of people that's a whole other episode, but but it's you can't work full time, but there are processes to help you try to get off disability as well.
And
It's a resource.
And as there should be, right?
Yeah,
Nobody's goal should be, I'm going to get on disability and I'm just going to be on this forever, right? There's a lot of individuals who get disability, but that allows them to get proper care, maybe different doctors. Maybe it allows them to get the treatment that they've needed. And then that helps them, and they can slowly, with time, rehabilitate to get into work, right? They're not going to start off with just going from zero to, whoop, I'm going to work 40 hours a week
yeah,
and I'm just going to be great. It's going to be, well, let's start off with a couple hours. And then, okay, well, that didn't seem too bad. Now let's add a little bit more. Let's get used to it.
yeah.
Right.
And
And
it's a
so,
spectrum. Like some people, there are some people that may never be able to go back to work. But my brain is just like spinning with everything that you brought today. This, I think, is so helpful. These have just been really insightful, and or you have been insightful. And then this is a great case studies to look at. And I just really, really appreciate your time and coming here today. I know that our audience does as well, because it can be scary out there. You're already overwhelmed with your disability, and then going through the process. I mean, you could just feel like there is no light at the end of the tunnel. So I appreciate this for our community, everything you do. And I wanted to give you the opportunity, for those of you on our website, www.speakinginspoons.com. We're going to have Adriana's bio again and link to her website. But I'm going to let her take over here and tell you about other ways that you can follow her. And we'll have links on the website as well.
thank you. Yeah, I know how hard the process is, and I know what it has to feel like going through it. And I don't want anybody struggling any more than they already do. And that's why I wanted to do these 3 cases, right? It shows that you're not alone. You're not the odd one. You're not the different one. This is just the way that Social Security works. And there has to be ways to work through that system. On our website, we have loads of resources, and we have some infographics that help explain as much as we can about the process and what you can expect. I do a lot of writings about cases, because I want to make sure that, I feel like federal court has nobody really talks about it, nobody really knows about it, and they're not sure what happens. But it's an important step, and these cases matter, not just to this person, but you're creating case law that somebody else can say, my case is like that case about the migraines that you demanded. Look at that case, and now look at mine. So it's really important for people to understand these cases. And I do a lot of conversations on LinkedIn. I want to make sure that people get as much information about this as possible. So anybody who wants to follow me there can get some more information, or because I talk about a lot of things. I have lots of opinions.
But But I love it. Like that's how we actually met, was through LinkedIn, and I can attest she writes like every day, and it's always like, I mean, she's reading about everything that is going on, like in case studies that's going on with like the Supreme Court. I know we were talking, and I always feel like I'm learning, and that it's just really helpful for our community. So definitely go to their website and follow her on LinkedIn. Whether you are disabled or you are a ally to the community, or working with disabled people, or a family member. And I know earlier we did talk about kind of what's going on with the possibility, like with the Supreme Court and Doge. I just wanted to pop on that for just a second. Why is this why does this matter? Like, what happens with this? Or could you explain what the Supreme Court is currently considering?
Sure. So the Trump administration received a decision basically saying that they can't get certain information from Social Security. And they filed with the Supreme Court saying, hey, don't hold us back. And that's what Doge is saying. Now, there are some unions and some other workers and other information that are fighting back by saying, hey, you can't get this information, what you're trying to do with it. And that's what we're currently waiting from the Supreme Court on, what they're going to do. So the Trump administration filed a request with the court, and that has been pending since May 2nd. They filed it. The court asked for a response to that action, and that was already filed on the 12th and the 13th. So there were two different parties that filed briefs in that regard. So now we're just waiting. This week, on Thursday, they released several decisions, but this wasn't one of those cases. But I do keep a track of this case and how it impacts. I mean, Social Security affects every person's life. Every single person who lives here or comes here, like, Social Security has their information. So it's really important that all of this be handled responsibly. And so we're waiting
with
to
utmost
see
privacy,
Correct.
Yeah.
So we're waiting to see what's going to happen with the Supreme Court. And I'll talk about it the second it comes down. I mean, I have an alert on the
Let's
blog.
bring you back on for a Spoony Sunday, because this affects people looking at your disability judgments, and
Everything.
like possibly it's like another judge saying, nope, not disabled.
Everything is up for grabs with this information.
Social Security, yeah, okay, that is scary.
Yeah.
But
So it is something
would
to
be
watch.
interesting if they decide, if they allow it, but give it parameters or something. Yeah.
Right.
Well, thank you, Adriana. And we are going to be bringing her, and I already talked about this. We're going to bring her back to do case studies for children with disability appeals. So this for parents out there of a disabled child. And if you have been, or if you're about to go into the disability process, or you've been struggling with appeals for your child, this will be a wonderful opportunity for you to learn a little bit more about that with the lovely Adriana.
I'm
Thank
excited.
Me too. This will be, it's always a pleasure talking with you, and I can't wait to have you back. And for those listening and watching, stay tuned for more looking through the clouds for my words for more episodes. We've got a lot coming up, slowly but surely. And save your spoons.
Bye.
Bye.
If you want to contact us, please send a DM or email to speakinginspoons@gmail.com with any stories you have, or would like to interview with us on any of our upcoming topics. And check out our website for all of our upcoming episodes and what's happening in the Speaking in Spoons community. at www.speakinginspoons.com. Thank you for listening to Speaking in Spoons, and have a great day.